Welcome to our final installment of our March Nonprofit Section CLE series. I'm Catherine Hecker, the section chair. Today, we're very excited to have Dr. Peter Lake present on the basics of higher education law. And Jody Snow will be doing the introduction, but I did want to mention one housekeeping item, and that is for CLE credit. Please remember, you do not need to take any action. These will all be reported for you by the bar. So Jody?
Hey, good afternoon, everyone. Jody Snow. I'm reporting to you from Abraham Baldwin Agricultural College in Tifton, Georgia. And it is my distinct pleasure to introduce Dr. Peter Lake. He's a professor of law at Stetson College of Law in Gulfport, Florida. He is the Charles Dana Chair and Director of the Center for Excellence in Higher Education Law and Policy at Stetson University College of Law. He is nationally known for his teaching and scholarship. He is internationally recognized expert in higher education. He has appeared on several major media networks, including NPR, ABC, and CNN. He has published numerous law review articles and other publications, including 5 books. He is a highly sought after speaker, particularly in the field of higher education law and policy. And we are pleased that he is willing to give us 2 hours of his time today for the nonprofit section of the Georgia Bar. And he is a graduate of Harvard College and Harvard Law School, and currently serves as a part-time senior higher education consultant with the firm of Steptoe and Johnson. And Dr. Lake, I appreciate your time, and we look forward to hearing from you. And thank you, everyone, for attending today.
Thank you for that wonderful introduction. And it is so good to be with everyone. Hello, Georgia. Hello, Georgia Bar. And I have to say it, but I'm thinking Tifton, as I've been instructed to do often, driving on 75 north or south. Frequent stop when I'm passing through Georgia. And I'm very pleased that I was able to offer this webinar today at the request of an alum who was working with you all up there. This is something I'm very pleased to do on behalf of Stetson College of Law and myself. Of course, all comments are mine, not the institution. I have about 2 hours to cover the basics of higher education law, and you'd be more likely to ride all the rides at Disney in 2 hours than be able to really truly hit all the basics of higher education law in a 2-hour span. So this will be a very fast moving presentation. I'll do the best that I can to take you on a tour of what I believe are some of the core ideas in education law today. Without further ado, I thought we might start with the business structures in the field. And it's really quite common to see the following, and I'll talk about each one of these points in a little more detail. When we're talking about business structures in higher ed, a great number of private institutions are organized around 501c3 status, and that typically means that they have self-perpetuating boards of trustees, sometimes called visitors. And I put the slide on here of no visitors because the self-governing concept in the 501c3 world is such that there's no membership class to vote in or out people, or even to comment on direction of the board. But one thing that has dropped away that was really common in the 19th century was the idea of visitors to the institution who would represent the interests of donors. That business structure died away for various reasons in the 20th century. Sort of a long topic if people were ever interested in that sort of thing. And what's happened is that we now have, fairly insulated self-perpetuating boards often that select their own future. That's had, I think, quite a bit of an impact on higher ed management, because it's really a survival of a business form that is not really common outside of higher ed or particular charitable institutions. Government can be the ruler of an institution, obviously, public schools, And you'll see things like regents, which is a formation of Rex and King, or boards of governors, et cetera, that may have significant role in managing governmental public institutions. For-profit entities still exist. They seem to come and go a little bit in fashion and significance from time to time. I think there has been a feeling in the field for a long time that there's a preference for public or private entities that are not for profit, but of course that does tend to mask the fact that even a government or charitable organization may have financial motives that may not be identical to for-profit industries, but have some motivation based on where dollars flow. So I always say in this business, follow the money, and you'll know how the leadership operates. Membership groups do exist. Now, these don't typically deliver educational services to students as such, although there is training that's often involved. And DuPont Circle in DC is the location of a great number of these groups. I will note that NASPA moved off DuPont Circle a few years ago, but in some ways, DuPont Circle is a concept as much as a particular space in DC. I remember distinctly coming into the field 30 years ago and being taken to DuPont Circle, and the person who was touring me said, "This is one DuPont Circle, ACE is here, and this is the seat of higher education policy in America." It's interesting, the previous administration, federal administration, moved a little bit away from a focus on DuPont Circle, but that over the years, DuPont Circle membership organizations have been very important. Foundations are definitely influencers in the field. Two of the biggest, the Lumina Foundation, excuse me, and the Gates Foundation, are extremely well-resourced and well-known in the field. And these foundations often have agendas and a significant amount of money to throw around that influences the fate of higher education. Accreditation plays a big role in our business, and understanding accreditation can take some nuance if you're not used to it, but one of the more important functions of accreditation is to give institutions, public or private, the opportunity to access direct and indirect money through the federal government. For example, student loans can originate to students who are attending accredited institutions, and of course, grants, et cetera, may go as well. Lending and grants obviously play a huge part of this business. This is a very publicly funded business, and we find increasingly that a number of schools are tuition driven, and the tuition in turn is driven by the availability of loans and grants and is dependent on maintaining accreditation. I'll just sort of point this out as we get a little further on into the presentation, but accreditation and also Title IV funding matter a lot to institutions, and it's one of the reasons why the Title IX controversies have been so significant to colleges and universities, is the need to maintain that flow of public funding. Governance. Let's talk a little bit about governance issues. These are sort of issues that have been coming up legally and politically. Accountability becomes an issue, particularly when you have self-sustaining boards. To whom are the boards accountable? If you're not familiar with the industry, private charitable corporations are usually supervised technically by the state attorney general's office, although it's very typical that supervision is often de minimis. There's very little government oversight of that. Increasingly, I think we're seeing more accountability via funding mechanisms, particularly the federal government and to some extent the state governments as well. Adaptability. How quickly can an institution move and pivot to new models? The COVID experience, I think, showed us that our governance structures were capable of a hard pivot when called upon to do so. But I do recall a quote from a famous person who said that changing a curriculum is like moving a cemetery. And for those of you who have worked in this field, it's pretty obvious that higher education tends to take its time to pivot and pauses quite a bit when doing that. How disconnected are boards, how subject to political pressure or even conflicts of interest? These issues are sort of in the news all the time. You know, the board that doesn't seem to recognize that the huge tuition increase has a big impact on retention or attainment of students. I'm in Florida, so I don't think I really need to belabor how political pressure can come to play for both public and private schools. And from time to time, we do see conflict of interest issues arise. I would say the vast majority of board members come to give, but occasionally some come to take, and that can lead to visible conflict of interest issues that need to be resolved. I will say that working in this sector, there's a tendency that I didn't see as much of in the corporate sector, but of course I worked Wall Street and some of the really big Fortune 500 companies, was direct operational board management. You've got to get used to the fact that the board will often want to get directly involved in even specific operational decisions, and it does create some exposure to the institution and individuals when direct board management occurs. So one of the challenges, I think, for 501c3s and even publicly funded entities, public schools, is trying to corral direct board intervention because it can have some deleterious outcomes if not managed properly. We are in an era of investigations. This, I think, has kicked in. I really noticed an uptick after Virginia Tech, the incident many years ago at Virginia Tech with the mass shooting. There has been a movement, I think, to create internal and external investigation culture. And you see it very visibly now around a lot of Title IX issues that are prominent nationally. Unionization has been popping up, and very recently we've seen battles over graduate assistants and athletes. And that process is still underway, is trying to figure out how collective bargaining can expand or contract in the field. And compliance. All colleges have a duty of obedience to the law. I don't know that this is always spelled out to board members and others very clearly, perhaps as clearly as it should be, but a fiduciary related duty is a duty of compliance, duty to follow the law. And increasingly, we live in a culture where higher education is becoming a compliance culture. Some of the mistrust that's out there has translated into legal mandates that force technical legal compliance for everything from Title IX to disability to environmental. We've even seen lawsuits that have come out now that talk about admissions potentially bringing too many students to a region or area that the infrastructure can't hold. And so it's a wild west of compliance as we see that area expanding rather dramatically. I think it helps to get a sense of how we work with university counsel and services and vendors in this field. And I had a couple of talking points here that I wanted to share with you to see if it could stimulate some thinking. Gosh, when I entered the business 30 years ago, I often would be the person who would introduce the general counsel to people on their own campus. When I visited, you might have one, maybe two lawyers for a very large campus. And the general counsel was, I think, badly distributed across many different areas. And it really became increasingly difficult to manage that level of interaction with so few lawyers. This has not historically been a heavily lawyered field. I noticed the change when I came from Wall Street, that the ratio of executives to lawyers radically changed. And you're seeing today that the services are often being provided by general counsel, but increasingly by boutique law firms that offer specialized legal services of all sorts, from digital rights management to litigation, and that seems to be a growing part of the culture. For law schools, higher education is a growth field. In a declining higher education market generally, the subsector of law school higher education training is actually really in a major growth spurt. Here's one of the tricks, and I think it's a big part of this program, is that when thinking about legal compliance, lawyers tend to focus on the letter of the law and strict compliance. But when translating this to education communities, it usually requires that someone have the skill to be able to identify the spirit of the law that intersects with educational goals. What are we shooting for here? What is the law trying to achieve that is consistent with our educational objectives? I suppose one example I could give is I worked with one campus that was struggling with new rules regarding comfort and service animals. And it became apparent that the influx of animals needed an area for the animals to be able to do their business. The board met to find a space on campus where the dogs, et cetera, could do their business. I don't think they were too pleased about that. Shortly after that meeting, it turned out that people who gathered for the experience of walking their dogs, et cetera, began gathering for other purposes, and there were recreational gatherings now occurring. Board had to meet again, and at this point they were pretty frustrated with this new legal change that was bringing particularly more comfort animals into the fold. And I remember explaining to the board that you had to look at this not just in a technical compliance way, but that human beings had learned alongside animals for millennia and had been partners with them. You see this in cave paintings, for example. And it's only recently that we've kicked the animals, and frankly, older Americans too, off campus. The law may be showing a bit of an intention to reconnect the value of learning with the animal kingdom. And, when put that way, instead of making it a chore, the board started to see that they had the opportunity to improve the educational environment by operating, quote, within the spirit of the law. What you don't want to end up with legal compliance is have people just checking boxes to check boxes. Why are we doing this? Why are we here? What are we accomplishing? Therein lies the inspiration behind the compliance standard. We also have to recognize the limits of the law and the dangers of legalisms. Increasingly, higher education is becoming a legalistic culture, and the law just can't fix everything. Moreover, educational communication is often very different from legal communication. Lawyers speak a language of mistrust and conflict. Education is exactly the opposite. We're trying to build relationships and build trust. And so being overly legalistic kind of baits an oppositionalism in communication that may work to our disadvantage. I had a colleague in law school who's since retired, very strict teacher of civil procedure, which are the laws of going to court, et cetera. And she's a real stickler for detail, and she would have a number of students come in after the exam went out and they would challenge her on her grading. And she's very upset about it. And I said, well, you have to realize that this is what you're actually teaching them to do. You're a hard litigator. They picked up the big lesson. They're just reflecting it back at you. And I don't think it had occurred to her that teaching in a legalistic way can bait people to intersect with you as learners who are legalistic. Those of us who deal with parents on a regular basis, we'll find that they'll often throw our codes and rules right in our face to have a conversation. It takes some work sometimes to get to the root of the issue and away from the hard legalisms. Liability insurance, indemnification, and who pays for the lawyers. Well, we could spend all day on this. Some of the matters that we deal with in higher education are subject to coverage and liability insurance, and the lawyers may be paid for. But I will say the cost of litigation and indemnification have gone up remarkably in the last 20 years. And today I can sit here and say something that I couldn't have believed I would have said if it were 1990. Institutions occasionally face liability claims now that range into the billion-dollar level of exposure. It just seems unbelievable, but it's happened more than once now. And we're seeing a great deal more risk, which is getting more attention from boards and even the states that support public university boards. A compliance culture implies compliance vendors and services, including CLE. And it's very important in this world to make sure that clients are receiving quality compliance services. There has particularly been an explosion of compliance vendors around Title IX. And I think it's important to vet any potential vendor for quality and capability, and not to be captured simply by the lure of the marketing that may go along with that. But I suppose where there are wars, there will be Stark Industries and Iron Man, for those of you that like that sort of reference. All right, let's take a quick tour of the history of higher education law. Again, 2-hour presentation. This is really a rapid fire maneuver through an awful lot of material. I like to organize the legal history of higher education into what I think are now probably 5 distinct eras. And I'll start with where we are today, which I'm calling Compliance U, very heavy regulatory compliance period that would have been very unfamiliar just before 2008. We wouldn't have seen nearly this emphasis on rules and regulations. This includes, for example, the new Title IX regulations. But let me take you back to a completely different era, the beginning of it all, a very, very long era of legal insularity. And this is often identified as the era of in loco parentis. We're going to have a little chat about that. Actually, prior to World War II, there were a multitude of legal doctrines that protected higher education from legal intrusion. In loco parentis, in place of a parent, was just one. The in loco parentis doctrine, when it was articulated, was used to justify university power subject to limited or no accountability. An example, it's an actual case. I mean, this is a Stetson case from turn of the century, 20th century. A young woman was ringing cowbells in a residence facility, which the institution, my institution, Stetson, regarded at that time as equivalent to insurrection. She was disciplined, and she said, "Where's the code?" And the university responded at that time and said, "We don't have a written code, but we have one in our head." And we applied it. And the court said, well, if you have it in your head, you don't even have to talk about it out loud. You can simply impose discipline. And in loco parentis permits you to do that. If you've seen the movie Animal House, that is actually the root of the comedic idea of double secret probation. Yes, there actually was effectively a double secret probation case, if you understand the reference to the movie Animal House. But there were many other doctrines, and this again could occupy quite a bit of time, but among them were charitable and governmental immunity. And so during this period, institutions of higher education were often thought of to have the immunities that the government, the charities, and families had from legal intrusion. Very few people now were alive during a significant period of American legal insularity. The high industrial period protected family, charity, and government from significant intrusion by law. That has completely changed, but that was the temperature at this time. The other thing that I just think I need to mention, because it feeds into another era, is that students were thought to have a privilege to go to higher education, not rights. And that if you were consuming alcoholic beverages and you were injured, you were the person responsible by the doctrine of proximate causation. These are just a few of many doctrines that I've written about in works that I've done that would have protected higher ed from legal intrusion. So in the era of legal insularity, higher education existed very much like Hogwarts, if you read Harry Potter, very distinct from the areas in which the Muggles lived, very little intersection between the two worlds, particularly the Muggle law intersecting with wizarding law. If you've read the books, you know what I'm talking about. If not, I'll try another analogy if you'd like me to. The era of legal insularity comes to a screeching halt in the 1960s and 70s with an explosion of civil and political liberties for faculty and students. Talk more about that in a little bit, particularly under First Amendment rights. But I can't emphasize this enough that, if you were protesting in the 50s and you were disciplined by your college, your chance to succeed in court on a First Amendment claim was next to zero. It would take the Supreme Court in the 1960s acknowledging that, in fact, students have rights in higher education and K-12 that they do not live at the schoolhouse door. And among the civil rights that are born are expression, the right of press, more emphasis on freedom of religion, basic, what we might think of as DEI rights today, if we can still use that term, rights to be free from race discrimination, national origin, sex discrimination. And a capstone moment for the civil rights era was the birth of federal privacy law. FERPA, as it's come to be known, which is on another slide, was passed in response to the fact that some institutions were claimed to have been blackballing people by keeping secret information and sharing it to the detriment of a student, for example, but the student had no right to see it or right to correct it. FERPA ended that practice by giving students the right to see their education record, and it requires procedures by which they can correct errors in a record. Intriguingly, the 60s and 70s period did not birth basic rights in other areas. And a lot of the work that we're doing today is a reflection of a partial novation or revolution in the 1960s that has been subject to expansion really ever since, minus this brief period that's been come to known as the bystander era. For example, safety rights. Students won no national right to basic safety in higher education. That was a very slow comer, and we're not even fully there yet, but certainly much farther along than we were in the 60s and 70s. No basic right to a quality education at an affordable price. Didn't really see that either, and no rights really by students to participate directly in the governance of the institution, that they may have been granted by schools, but they weren't winning basic constitutional or statutory rights to that type of a system very broadly. I'll take you into the bystander era. It's now the 1970s, and I don't know where you were at the time. I had a polyester suit, and there's a picture of it, but it shall not be shared. And I remember the 60s and 70s being quite the laissez-faire time in American alcohol law in particular. And along came a series of cases during that period where people argued that institutions should protect students from alcohol-related risk. And almost to a person, the judges around the country rejected the idea that there were general responsibilities to reduce risk in a high-risk alcohol culture. In fact, one case went so far as to say that college is where students learn to drink, and a few will be lost along the way. And it's all to the greater good of socializing people to the use of alcohol. I mean, it's kind of a Mad Men type thinking in the judiciary during this time. That was destined not to hold up. And, I had coined this term bystander era in one of the works that I wrote. And it's now actually in several legal opinions recognizing that root. But increasingly, courts have begun to reject the idea that students are completely unable to assert safety and responsibility rights. And we entered, I think, a period really from the 90s forward where we started talking more about a facilitator university, which would recognize that it plays a role in student safety, doesn't necessarily control it or dominate it, but each person in each institution uses reasonable care collaboratively to facilitate positive and constructive outcomes. And that idea has been catching on. Now, here's an important point. A lot of people will say, oh, this is the return of in loco parentis. And from a legal point of view, this is actually incoherent, because in loco parentis was actually an immunity to tort responsibility in its heyday in higher education. And if it were to return, we would not be seeing cases and regulations that impose safety duties. In fact, I think more fundamentally, it's very clear to me that the new responsibilities have nothing to do with parental responsibilities. They're business-like responsibilities, most similar in many cases to the hospitality industry. For those of you that go a little deeper into the subject, I would encourage people to become familiar with hospitality standards and legal standards, because increasingly I see higher education being held accountable to similar standards. This is more common. Yeah, we are probably as an industry closer to hotel, motel, Holiday Inn, or cruise ships, or even theme parks than we are some other businesses. And you'll notice there's some similarity in some of the standards now that are being applied. 2008 was the big meltdown financially, and I noticed that it wasn't long after that that red, blue, and purple political folks all began to have their own gripes with higher education, a certain loss of trust, not the same gripes necessarily, but concerned about what we were doing. And when public trust falls away the way it did and has, there's a tendency for compliance metrics to rise. And I think you can clearly trace that with the Title IX evolution. Last point is, for many years, courts have said that the basic relationship between a college and student is contractual. Yet, it's often not clear where the contract is or how it was formed. It almost never has the structure of something like a standard UCC agreement or sale of a home or sale of a car. And often, I think when courts said this many years ago, they were a bit facetious, because they would interpret the contract, but the students typically had very little authority to win the case. Increasingly, I think the law is looking at students as consumers in some kind of contractual relationship, and they're much more willing to enforce contract responsibilities than really at any time before. I've written a couple pieces about this, one in the Chronicle. All right, no tour of basic higher education law can miss this slide. How do we know the difference between public and private? Well, the case books, the teachers all typically start where most everyone's ever been trained on this, is state action. That the way you distinguish a public from a private actor is to focus on legal tests for when an actor is engaged in so-called state action. I don't know how many of you have delved into this. The Supreme Court has given us several tests for state action, including nexus tests, symbiotic relationship, and one test actually focuses in quite a bit on who appoints the board and whether the board is a majority of appointees from the state. So there are different ways to look at this. I think in practice, we often have a pretty clear idea of who's public and private. But I want to pause on that thought and come back to it in just a minute. This taking tuition money that's subsidized by the federal or state government turn you into a state actor? The answer is no. Is being heavily regulated make you a state actor? The answer is no. However, what we are seeing is that through various powers, particularly granted to the federal government, you now see that public law metrics are often projected onto even private schools, such that they're forced to follow public school or public law metrics for state action. This has become particularly apparent recently with Title IX, because Title IX proceeds through Title IV authority and funding. And private schools who take the funding have to come into compliance with Title IX. And Title IX regulations recently passed have explicit due process standards that are believed to mirror federal due process. So the Trojan horse of public support has brought public law even to private campuses. Vice versa, I work on a lot of matters where the institution that's public gets sued, but the issue ultimately comes down to private law construction, for example, breach of contract. And then I'll just throw something else out, that in this weird and wacky world of what was once a clear distinction between public and private is no longer, we are definitely seeing that public schools are often supporting themselves with a great deal of private financing. They're doing their own fundraising, and vice versa. Private schools depend heavily on the public offer to stay open. And so what was once 25 years ago sort of a simple part of a higher ed law class is let's study state action. It's not so simple anymore. And we're seeing that the public and private world is imitating each other, and in many cases crossing over. A recent case in the Third Circuit held that a student conduct code at a private institution has implied due process rights. Hadn't really seen anything quite that explicit before, but it shows you the bleed over between the two areas. We're watching the Supreme Court, and I can't talk about everything big that's happening, but I want to hit a couple. I think it's very hard right now to not be paying attention to these cases if you're really serious about the Supreme Court's intersection with higher education. The Bostock case, Title VII employment law. Bostock held that certain members of the LGBTQ community are entitled to be free from discrimination under Title VII. That case has been subject to a couple different interpretations that courts and the Department of Education are fighting over, but it kicked the door open to what we might think of as LGBTQ rights in employment. However, shortly after that case, the Supreme Court decided Lady of Guadalupe. And in that case, the Supreme Court held that religious institutions have the right to control the ministers of the faith, and if necessary, can violate certain forms of federal anti-discrimination law in the pursuit of ministers who stick to the faith that they're supposed to teach. It is an exception to Bostock, and it also signals a trend that I think is very important to keep an eye on. Higher education may be trifurcating now: public, private, private sectarian. The rule systems are beginning to shift. And so, for those of you connected with private sectarian institutions, this is a Supreme Court that's putting a lot more emphasis on religious freedoms, and the rights and responsibilities on a faith-based campus may differ quite a bit from a non-faith-based institution, public or private. Many of you remember the NCAA in Alston case. It really seems a while ago, and I guess that's COVID that makes this happen, when a year now seems like 10 years. But the Supreme Court towed directly into sort of name, image, and likeness for athletes, and has created a revolutionary approach to how it imagines so-called amateur athletics. I noticed that the court is becoming very textualist and originalist and historicist by its own terms. And one thing they're now willing to do more than ever is to tell us about higher education history through their lens and turn it into law. That's very visible in the Alston case. Some of you may have picked up the West Virginia EPA case, and it's not a higher ed case, but it talks a lot about regulatory authority. And this is one not to miss, because the Supreme Court has been casting shade on some regulatory activity that it believes goes beyond any kind of statutory mandate that the regulations purport to be based on. Here's a good example that I think is headed to the Supreme Court sooner rather than later. Title IX is a very short statute. how do you tease out of that complex regulations with a specific grievance process? Will the West Virginia case prognosticate that the Supreme Court might tell DOE, you've just gone too far, you can't be this prescriptive about grievance procedures? It's hard to say, but the logic of that case suggests that people will test it. The Dobbs case, obviously reproductive freedom, but huge implications for privacy rights generally, beyond reproductive freedoms. And we're in the middle now of trying to figure out what some of the implications of the Dobbs case really could be. Watch the Supreme Court return to that topic at some point because of the complexity of it. Here's one, maybe two that you might have missed, and I think they're extremely important. The Cummings case now eliminates the opportunity for plaintiffs to recover emotional distress damages when they're suing pursuant to statutes and regulations promulgated under Title IV. Implication of this is that Title IX cases will not qualify for emotional distress as a damage. This is often what the plaintiffs are seeking in a large measure. And so the Cummings case might be somewhat of an insight into what the court might be willing to do with Title IX generally, because they did eliminate a whole range of sanctions and remedies in that situation. And here we go again with Counterman, another true threat case. How much does the First Amendment protect threatening language, particularly when the person making the statement claims that they did not know or intend to be threatening? This case has been in front of the court before in another form. Some of you may remember the Alanis case. Court didn't really take a firm position. The Counterman case promises potentially to give us a more strict interpretation of how this works. Went the wrong direction there. Sorry, folks. Here's Bostock. I thought you might want to see the holding. I think particularly for CLE purposes, this is very helpful. I do want to make sure people realize that this holding, as it is articulated, is exactly and only the holding in the case verbatim. The case is often characterized to have broader implications, but I should point out that Justice Gorsuch wrote the opinion, a very strict textualist, and he pointed out, as the court did, that there's the potential that Bostock could be overinterpreted, and the court basically said we reserve decision for future cases, baiting more to come. One of the big questions today is, does Title IX extend as far as Title VII? A very recent case in the 11th Circuit, where I'm living, has taken a position that Title IX and Title VII are not coterminous in their protections, and has jumped into an ongoing debate about rights that transgender individuals may have to bathrooms. I mentioned the Guadalupe case, the ministerial exception. Here's the big question that comes to me, maybe a couple out of the Guadalupe case, is, will Guadalupe be extended to students? So if you can punish a teacher for not following the faith, can you do the same with students? That has yet to be decided by the Supreme Court, although the matter has been taken up in some lower courts. And then, who is a teacher and what are the tenets of a religion? Kind of interesting questions. And I've been throwing out, ever since Guadalupe came out, the idea is, could one have a faith in science that would be equivalent to a faith in an almighty creator? And would that be equally protected under the First Amendment? I really have no idea. I just sort of throw it out there. Perhaps I've watched the movie Nacho Libre a few too many times. Let's talk about employment law. Out of nothing came a lot. And remember, we talked about that civil rights area. Just an explosion in and around that period of basic employment rights that we now live and die with in many fields, but particularly higher education. You'll notice that there's protection for race, color, and national origin, sex, age, occupational safety, labor standards, family and medical leave, a variety of disability laws that have been reinforced persistently, veterans' rights, and there are even implications under the First Amendment. So in a typical law firm that represents higher education these days, employment litigation is bread and butter. You'll see a whole area of activity devoted just to that. Disability law has become its own specialty, as has Title IX in many ways. Watch age discrimination to start to grow in importance as well. We see some particularly challenging areas these days, more so even because of the new regulations the department is about to utter. Lots of discussions about family and family leave and pregnant and parenting rights. And it appears the Department of Ed in particular has made this a signature issue. We'll see how that develops, but I know there's been a lot more emphasis from the regulators on that. Disability discrimination remains foremost in terms of trying to avoid and correct. And a lot of the discussions that are out there legally are about qualification standards, because under typical disability law, even if you are disabled, if you're not qualified for an activity or service or benefit, then you're not entitled to an accommodation. So what does it mean to be qualified? Comes up quite a bit. Reasonable accommodations. I don't think there's a campus today that hasn't probably had at least one accommodation issue pop up. It's so ubiquitous. And disability law also often permits you to deal with directly threatening behavior in a specialized way. Title IX and Title VII both deal with sex discrimination, one principally on employment, the other one not exclusively. And the 2020 amendments have actually been really helpful in this regard, particularly with Title IX. We see very specific standards relating to that which is considered a Title IX violation. This is now built into the regulations. We probably will see the return of what's known as a hostile environment standard with the new regulations that are due out in May of 2023. We shall see. Department's been behind on a lot of stuff, so we're not sure they're going to get it out. And by the way, these two statutes definitely intersect with student employment as well as full-time professional employment. Tenure, kind of the dirty word today in higher education to some people. Tenure gets its inception in the United States somewhere in the early 20th century when the American Association of University Professors begins crafting the idea that professors should not be organized as a union, but more like a skilled guild or operating system. Think AMG construction on Mercedes, for example. And mid-20th century, courts began to recognize some of the principles that had been promulgated, including the idea that there's a property interest for a tenured faculty person to continue employment, and that due process is required before any kind of termination. What are the benefits? Well, there's a lot of detractors, but the articulated benefits of tenure include academic freedom, promoting free speech, promoting academic integrity, getting quality teaching through longer term or permanent employment, and that one of the benefits of tenure is the fact that it often has benefits. In other words, human resource benefits like generous lifetime benefits for workers. What are some of the criticisms? It may be hard for junior faculty to advance. COVID has had all sorts of weird impacts on tenure and academic freedom. Are we getting a multicultural community of teachers quickly enough? If people are locked in for life, it could take 10, 15, 20 years for turnover in a position. Scholarly productivity, is it really there? Are some people just resting on tenure and not doing enough? How costly is it? Are there underclasses of academic employees that may resent tenure and vice versa? And I do think, honestly, among practicing lawyers, there's been a bit of a cynicism, even backlash against academic freedom, even tenure, because you will see people do some pretty egregious stuff, and then they'll try to protect themselves by claiming academic and freedom or hiding behind the tenure procedural protections. I've been writing about this. I probably need to get more out there on it, but I'm kind of watching this happen. Tenure is in a bit of decline in the United States, pretty steep in some places. You might have noticed that Florida just announced a new round of post-tenure review, which is often considered a weakening of the system, but it may not be. But the one thing that does seem to be very visibly underway is that tenure is almost now becoming a student right. And when I say it, people usually are like, I don't get that. Well, think about it. These days, once you're matriculated to a school as a student, it really shifts the balance of power to the student in a lot of ways, because to throw a student out, you have to prove with really clear standards that they fell below academic or behavioral standards. And more, the systems that protect students when they're thrown out are built on due process models, much like the 2020 amendments for Title IX regulation. So, you're seeing this shift to students actually sticking, teachers maybe not as much as they used to. And I think it's a direct result of who pays the freight. I want to talk a little bit about, real quickly here, equal protection, civil rights, and multiculturalism. We've had a lot of battles over race, and it's culminating now right in front of the Supreme Court. In fact, for all I know, they've decided the case while I'm on this CLE. It may be that a long history of diversity in admissions consideration may come to an end, and we're watching that like a hawk. Race obviously involves strict scrutiny. The court has said it's not impossible scrutiny, but it is extremely difficult. Higher ed's one of the few places that has been allowed to meet the strict scrutiny standard, and it may be those days are numbered. Sex, gender, and sexual orientation at best get intermediate scrutiny from the court. The famous case is the VMI case. VMI was not permitting women into its adversative training program, and they claimed that at that time that women would not be able to handle it. Ruth Bader Ginsburg had a different idea, in part based on the Israeli army, and struck down the policy of a male-only admissions for so-called adversative training. Very famous case in our field. Class and economic discrimination, the Supreme Court uses minimum scrutiny, which means really there isn't much scrutiny at all. And some people have been arguing that this is the thing that colleges should be focused on, is economic and class adversity. I'll let you all debate that, but Rick Collenberg and others have made a point of that. What about core mission delivery? I mean, do we see a glimmer of hope for students that they'll win basic rights to a quality and fairly priced education? The battle over gainful employment regulations that went on for a while was sort of emblematic of this. But even today, although I think the public may be voting on this and very concerned, we are still not getting hard, specific outcome-based federal regulation around core mission. So we'll have to see how that evolves. Safety and wellness, quite a bit out there now, but no national singular mandate on all forms of safety. The Clery Act is largely a campus crime reporting bill. Title IX proxies as a safety wellness statute because people who are victimized by sexual violence will be looking for remedies and possibly sanctions. Safe and Drug-Free School and Communities Act is still out there. The Department of Ed seems to touch this every now and then, but many of you know it through the biannual review process where one has to do a biannual report. Last but not least, disability law, not protected in the Constitution. Equal protection doesn't do that, but Congress in particular has been very active protecting the rights of disabled Americans. And in a famous series of cases, the Supreme Court struck down some disability law, and Congress retorted with reinstating rights for the disabled people, and then going even the distance that much further. Take a little time. This is pretty complicated conceptual stuff, but I think we probably should get some feel for this. How does one approach disability law? Now, I will do this to a certain amount of injustice because there are many disability laws. They don't all function exactly the same way, but anybody that's entering sort of the basic understanding of higher education law probably needs to understand the flow of disability law in a typical matter. And it starts with whether someone is technically disabled or not, hence vel non. Some people who have challenges are simply not considered to be legally disabled. And many people who are legally disabled, temporarily or partially, are often not identified as such, but they are technically entitled to some legal intervention. The question comes down next is, if you do have a disability, are you so-called qualified or other qualified for the activity or benefit that you're attempting to participate in? You don't require employers or service providers to fundamentally alter the service or activity, but people do have to articulate qualification standards if they expect to stand on them. The famous Supreme Court case is there was an individual who lacked auditory acuity, deafness, and other nurses felt that that was a qualification of a nurse, that you had to have hearing at a certain level. And although that nurse trainee was disabled, they were considered not qualified or otherwise qualified for the activity, which means they can be removed. In higher ed, we don't often or always articulate qualification standards. We do so on the employment side, but not so much for students. And the Department of Ed has permitted us to proxy for technical requirements, or other, I'm sorry, qualification standards with technical requirements, such as minimum academic standards and behavioral standards. I guess the best way I can explain it, in law school, I had a pilot, and one day he just raised his hand. He said, "Professor Lake, all of the cases we read are crashes, and you just keep telling us not to crash." He said, "You know, when I was a pilot, they taught us how to fly and land. And so we were given specific qualification standards and skills to shoot for. Here, you just see if we get a low GPA, if we're act out, but not really sure I know how to do anything. I know how not to do things." And we've been allowed to get away with this in higher ed for some time. More on this in just a second with the Spring Arbor letter. Okay, well, let's assume that you are disabled, you are qualified, you are entitled to reasonable accommodation, but it's important to remember that the accommodation standards are very different in K-12 from higher ed. K-12 education is typically a matter of right by statute or constitution in a state. So the accommodation has to give you equal outcomes. When you get to higher ed, there's no such promise. So the accommodation standard typically transforms into equal opportunity. That, for most people, is a result in lower levels of accommodation than they might have been used to. And one thing that's noticeably absent in most higher learning is something like an IEP, an individual education plan. Many higher ed people don't even know what those are unless they have kids or have had one themselves. Whether something is reasonable or not is often a big debate, accommodation. And what I typically train people on is that the law really looks to the ADA or disability coordinator to be the key decision maker. So people might lobby for one thing or another, but it really needs to be professionally managed to get good results. So I promised this, the Spring Arbor letter, very famous in the field. There's one last feature of the sketch of disability law, is that someone who is disabled, who's qualified, has an accommodation, could still be removed if they present a direct threat. Now, years ago, some hoteliers, in discriminating against people with disabilities, would turn people away and say, you can't stay here tonight because you might hurt yourself. Our rooms aren't protective enough for your form of disability. That kind of thinking was eliminated by a specific regulation promulgated by the Department of Justice that becomes prominent in the Spring Arbor dialogue. Now, here's the thing that Spring Arbor did that caused a lot of consternation is some people interpreted that to mean that institutions could not punish or intervene with respect to direct threats when they were solely to that person's self-harming behavior. Since then, the department has clarified that that is not their intention, that in fact, you absolutely can do that. But the Spring Arbor dispute really kind of raised that, and a lot of people were very confused as to what the department wanted. The First Amendment. Let's take a quick toe into this, and maybe we'll take a little break after we do this slide. Where is the Supreme Court on the First Amendment? Well, they spend a lot of time talking about who, what, when, and where. And so when you're thinking about speech, you do want to think about the who's coming, what they said. But it turns out that when and where are very significant in managing speech rights. For example, institutions can create reasonable time, place, and manner regulations. But in regulating speech, we have to be careful not to chill good speech over broad or vague in a way that intersects with legitimate speech or makes it hard for speakers or others to guide their behavior. And you need to be particularly careful going after content and especially viewpoint, because it triggers a very high level of scrutiny. And I have noticed that a lot of schools will react to a speaker with a particular topic, and they'll find themselves a bit hamstrung in terms of what they're able to do, especially in a public school campus. However, spaces and places can be regulated. So just to say it bluntly, the linen closet is not a speech zone, and you can stop people from protesting in and around a linen closet. There are also non-protected categories of speech. So certain things do not get First Amendment protection. Defamation, for example, is one of those. Student Activity Board funding has been an interesting issue. The government usually says that you can't force people to speak and you can't force people to buy speech that they don't like. But college campus bets are off. And in the Southworth case, which you see here, the Supreme Court took the position that because of the nature of higher ed institutions, that we can charge activity fees with no opt-out, so long as those fees are put into a fund that funds a diverse slate of ideas and speakers and doesn't merely grandfather in the same acts every year after year. Pretty controversial case, and I think if I were to take a stab at this, I'd say that this is probably the one metric from the Supreme Court on speech that's more likely not to be followed clearly on a campus than others. So if you're not familiar with Southworth, I think it's a good idea to pull that up and take a look. Related, registered student organizations and association. Way back when in the 70s, a group of students wanted to form the dreaded SDS chapter. And if you remember that time, and I assume you do, the SDS was often considered a very dangerous organization. Seems to have been a little overplayed since history has evolved. But at the time, there was quite a bit of antipathy towards these groups. One tries to form, and they're told they can't form. Supreme Court comes back and says, you can ask people to sign a document or agree to follow reasonable rules and regulations of a campus, but you can't refuse creation of a group like this just on the possibility that there might be violence or danger. Healy and James is foundational for a number of industries that intersect with us, including the Greek letter organizations. It is the mother, so to speak, of the right to associate. A trickier case, one I think is very vulnerable with today's court, was CLS, Christian Legal Society versus Martinez out of the West Coast. Here, the campus said that if you have a student organization, you must accept all comers at the first meeting. So whoever shows up gets admitted as a proto member. Now you can sort them out after that if they aren't following rules and regulations or ideas of your group, but you got to let everybody through the front door. CLS objected and said, we should have the right to block people who don't believe in the Christian legal faith or Christian faith. And university said, nope, got to let everybody in. Supreme Court tightly divided case held that the institution could divide on this basis, but boy, there was a lot of ink spilled on both sides about where the line is. Really does bait further litigation of the Supreme Court. Employees, so interesting. You won't be in employment law and higher ed very long before you hear somebody throw out the Garcetti case. Kind of a famous case, and its more recent cousin, Lane and Franks. What's Garcetti all about? In a prosecutor's case, the Supreme Court basically said that when you work under the direction of a prosecutor, your speech rights are severely curtailed because, in effect, you work as a mouthpiece for that prosecutor. There's quite a bit more to that case than the way I articulated it. Now, it's come up in cases that are very unlike the way a prosecutorial office operates, and such that when we're thinking about prosecutors running an office, it's not like professors who usually have quite a bit of latitude. So in that Garcetti case, there's an exception that's noted that it potentially applies to professors. We're wondering what the court's going to do with it. They haven't said a lot about professor rights in a while. And given the culture and climate, I suspect they will. So Garcetti is sort of on everyone's lips. Lane and Franks was pretty obvious issue. Someone was called to testify by subpoena and testified under oath, as you must. And then there was an adverse employment result because of what they said. And the court said that you could not retaliate against somebody who's a whistleblower or otherwise under subpoena and testifying truthfully. And last but not least on this slide, and this is where I think we'll take maybe a quick couple minutes stretch here in the middle, because I think that always helps in these things. Tinker in Des Moines in particular is the godfather of students having a right to speak. This is a famous armband in the classroom case where a passive armband protest. Court said you don't forfeit your expression rights at the schoolhouse door. Hugo Black, of all people, dissented and said this could be the end of college and high school discipline if we're not careful. What's happened since? The courts have trimmed back some of those rights, but still do acknowledge the broad brush. But perhaps the most interesting one, and it makes a great place for a break, is the Supreme Court recently decided the Mahoney case. And this was the one involving the cheerleader who expressed herself about a coach in a very unflattering and possibly vulgar way. She was disciplined for it, even though the conduct occurred off campus. She went all the way to the Supreme Court, and the court basically said this is her time and her space. She's not operating within the confines of the schoolhouse or its usual hours, and held that the student did have a free speech right to protect her from that kind of punishment. So when we come back, I wanted to do a little bit more with First Amendment. I want to talk a little about forum analysis. Got to talk about religion, a little bit on press and academic freedom. So let's take just 2 or 3 minutes here, and I'll be back on. Time to check your phones, and then we'll resume the story. So see you in just about a couple minutes. Hello, everyone. We're back. Hope you enjoyed your minute or two to yourself to check your phones or whatever you do. Back to the First Amendment. I've been really urging people that come into this field to focus on spaces and places as much as speakers and content. And the Supreme Court's actually given us a really helpful blueprint for how to manage spaces and places. There are actually basically 4 so-called forums, hence forum analysis. You can have a traditional or designated public forum, a public park, or a newly created park. You can have a non-forum. I'm going to the bottom of the list, which would be a linen closet, because some spaces are not designed for speech at all. Going up from the bottom of the list, you can have a non-public forum. And I joke about this, but a lot of college presidents' offices really function like non-public fora. In a non-public fora, it's like Thanksgiving dinner, you can control both viewpoint and content. And if you work in the field long enough, you will talk to a college president in their office and bring up an idea and be politely told that they're not the least bit interested and asked to leave. It's just going to happen to you if you do this any length of time. That is a hallmark of a non-public forum. This is my space, not anyone else's, and we can set both the tone of viewpoint and content. Now, this is where a limited public forum, which I think a lot of spaces in higher ed actually fall into this. A limited public forum, you can structure the content, but you have to be careful about attacking viewpoint. And that can be a little squirrely for non-lawyers, so I'll just take a second on that. You, for example, could have a theater, and it has content restrictions. In other words, you put on plays. You don't play water polo or hockey in this place. But within the range of theatrical productions, if you set it up as a limited public forum, you would have to allow a range of viewpoints. So you would have theatrical productions that might span a wide range of viewpoints, and perhaps ones that even could potentially offend people. Classic example of a limited public forum. Little hint, a well-functioning institution does a mapping analysis and knows what its spaces and places are for, and makes a space for everything that's on this list. This court has become very interested in establishment issues, and particularly impairment of religious issues, free expression, so to speak. And I threw the Tanzan case out because it got a little bit of non-attention, and I think it probably deserves more. The Supreme Court, around Christmas time, 2020, drops this case and tells us that the Religious Freedom Restoration Act is a super statute designed to protect free expression. And the court even recently has begun to talk, and at least some justices have, as if the expression of religion has an extremely special place in the hierarchy of viewpoint. We've always known it to be viewpoint protected, but perhaps it's the viewpoint of viewpoints. Watch this court get more interested in protecting religion on its own terms. My colleague, Bill Throw, who's the general counsel at the University of Kentucky, writes extensively about recent cases on religion in the Supreme Court. I suggest, if you want to sort of see the court's view through his eyes, you can almost hear him sitting next to some of the justices. Whether you agree with it or not, he can give you a pretty accurate take on what's happening right now. Freedom of the press hit colleges. Privacy, I mentioned that before. FERPA, which is the federal privacy law, and also access to records law, is one form of privacy that has significant impact in our field. You see a lot of things we just can't comment on publicly because FERPA protects student records. But privacy goes beyond that. And I think one of the big debates that's happening right now is, what did the Dobbs decision do to privacy in general, including the Roe and Wade case, but even some of the substantive due process cases that had been out there protecting privacy. And, there's different ways to look at the Dobbs case, but there's no question that it rocked the boat on privacy law, at least federal privacy law. What about academic freedom and freedoms in the academy? It does seem that freedoms in the academy are now becoming increasingly shared among faculty, students, staff, and even shapeholders in the community, and that ideas of academic freedom are confronting 21st century mentality. it may be that the 20th century vision of academic freedom legally is beginning to wane. Much longer story. Due process, dum, dum, dum. We don't have an infinite amount of time, so I won't belabor this too terribly much, but there is an interesting reality about due process at a federal level, is that the Supreme Court in Horowitz and Ewing never squarely held that students have due process rights in higher education. Many people tout it as if it's a done deal, that there's federal due process for college students. Supreme Court's never squarely held that. I think there is, but I think they hesitated for some really interesting reasons. And what you're more likely to see are lower federal court cases, such as the three that I have here, that begin to define new process rights for students. And the Baum case is famous for establishing a right to cross-examination. The Doe and Sciences case is famous for saying that private schools may have implied federal due process rights in their student handbooks. It's a fascinating idea. The entire Third Circuit considered the issue, so it's not as if it was an anomalous decision by one judge. It's a significant ruling by the Third Circuit. And the Purdue case had quite a bit to say about this as well, because one of the tricky things about establishing due process is there a property or protected liberty interest at stake? And it can get a little squirrely sometimes. And the Purdue case, like many other federal circuits, is saying that there is one, but well, we'll have to hear the Supreme Court on this. And so prediction here, we're still waiting for the big rock the house due process case in higher education. It has yet to occur from the Supreme Court. What federal due process doesn't cover, private contract law might, hence the private law mandate. And I'll take you back to a 2000 case against Brandeis that was, I think now in retrospect, the godmother or godfather of a burgeoning line of cases that makes it clear that breach of contract on procedural rights can be a major avenue for argument and appeal in higher education law. This is all platformed off the fact that starting in the 1970s, really, colleges around the country began developing legalistic codes with professional code administrators that feature, legalistic rules, procedures, and sanctions. The build out of something like a college court system, starts in the 70s and may be perfecting right in front of us. It's kind of interesting because, the German colleges that we modeled a lot of our public land grant institutions in the late 1800s. We took sort of German ideas about how to organize education. The Germans actually had college courts and prisons. We never picked that up at that time, but it looks like we're coming around to it here at this point in time. What do modern conduct codes look like? Well, a couple of things I mentioned: legalistic, very heavy on objective standards, often multiple codes referring to other systems. They can be very difficult and slow to change. I do a lot of forensic code work and code revision, and it takes quite a bit of time and skill. Codes tend to be managed by specialists now, and one of the more common things is to divide academic and conduct processes. Some schools have an honor and a conduct code, for example. Shifting to safety law, well, what do we know? The bystander era really took the position that college students aren't owed safety rights the way they are owed political and civil liberties. And we've seen since that time a steady attack on the idea that there's no duty or legal responsibility to protect student safety. This has really been a big part of my career, and it's been very much an incremental evolution over 30 plus years. But we're seeing private law, tort law, and civil litigation, particularly around negligence standards, slowly and steadily evolve. Liability has been a bigger exposure than ever, I think, given in recent times. And of course, the settlements that we're seeing now too are much larger than they used to be many years ago. So we're sort of seeing a steady increase of the application of business law, but that Bradshaw case from 1979, this is the quintessential bystander case. Students were injured in a car crash after a drinking incident, and the court said school had no duty. But since then, courts have begun to rethink these no duty rules. And I'll show you a couple that are important here. Nova Southeastern here in Florida established responsibility in externships, and for many it implies duties in study abroad. Healthman is a case out of Massachusetts that specifically talks about alcohol-related risk as well as sexual violence and some responsibilities that may exist there. The Regents case, which I know is Rosen, established that students have safety rights in the classroom from violent assault. And the Wynn case out of Massachusetts, another Massachusetts case, established that there may be rights of protection or at least negligence responsibility associated with student suicide. These are some of the more notable cases, and you'll notice that the ones that are most ambitious are very recent. So that Bradshaw ruling hung on for quite some time. By the way, for what it's worth, the Regents case in California essentially overruled Bradshaw's holding in every case that it was based on that case. They sort of methodically went through the root cases and the subsequent cases to eliminate those. I'll take a little focus on two of these cases. And the Wynn case, remember, this is the suicide case that I mentioned just on the other slide. The thing that both of these cases talk about, which is something very new in higher education law, is that the college-student relationship is itself sufficiently special to create some duties of safety or care for students. And they both involve rejection of the Bradshaw principle of bystander. In fact, they do it explicitly. Many of them are based on a facilitator model. I think you might have talked about this facilitator area a little earlier, that implies that we share responsibility and we don't shoulder all of it. More reasonable, balanced, and measured responsibility. And I will give a shout out to the Jed Foundation that I've worked with in the Wynn case. With respect to student suicide and self-harming, the Massachusetts court all but said, follow what the Jed Foundation is telling people to do, and you're likely to have done what's reasonable in the circumstances. So these cases show a significant advance in terms of safety technology entering the law, and also a more sophisticated and balanced approach to sharing responsibility for serious risk to students. Here are some of the major topics in safety and the experience that students have. And again, I'll sort of take you through these, but I thought I'd at least show you this list. When I'm doing this kind of work, this is almost a checklist of things that folks are going to look at in terms of law and how it intersects with these various topics. So let's do sexual assault first. Title IX has become incredibly prominent. It seeks to reduce or eliminate barriers to education opportunity caused by sex discrimination. That's its mission, hence the spirit of the law here. Early on, Title IX for a lot of people was sports equality, but we're seeing now much more emphasis on hostile environment, sexual violence, retaliation, and increasingly with the Biden administration, it appears there's a bigger focus on pregnancy and reproductive rights. And so Title IX is beginning to span quite a bit more than it was originally thought to have intersected with. I do remind people that Title IX is always looking for institutional response, not perfection. And it is connected with responsibilities to engage in investigations, at least regulatory requirements to do that, so that institutional response compliance for this kind of work involves having a grievance system and having trained investigators available to investigate when necessary. Thought we might talk about the regulatory process briefly, just quickly. I didn't get a lot of admin law in law school that really helped me that much with practice in higher education. I pick up a lot of this on my own. I was aware of the Administrative Procedures Acts and such, but I think one thing that I needed a little tuning on when I got into practice is that it gets important to know how the robots, the regulators, think, because they make rules in some cases. Other times they can actually involved in adjudication. They can issue guidance, which is not the same thing as a rule. They can audit, they can investigate, they can communicate in other ways. More recently, the Department of Education has been issuing interpretations, which signal the way that they would intend to apply the rules to people. Very specific ways of communicating. One of the big challenges that seems to be on the horizon is, will agencies continue to have the scope of authority that they've been asserting? How much judicial review will occur? And more often than not now, as soon as we have a new set of regulations, lawsuits put a hold on it as they're examined for their compliance with APA standards and other constitutional and statutory requirements. We most often intersect in this field with the Department of Justice or the Department of Ed, DOJ, DOE, but there are other agencies as well, including fair labor standards, et cetera. What about alcohol and drugs? Alcohol and other drugs remain connected as a core risk to just about everything that goes wrong in higher education. When you talk about hazing or sexual violence, alcohol doesn't cause these things, but it's often correlated with it. And so working on alcohol and other drug prevention remains a really significant goal for all institutions that want to improve retention, want to reduce violence, et cetera. The law, Safe and Drug-Free School, requires a biennial review of programs. We are supposed to have science-based prevention programs that use so-called environmental management techniques. If you don't know what these things are, there is literature on it. We could help you with that. Your programs are supposed to be assessed. And I think one of the big challenges has been trying to do alcohol and drug work, so-called AOD work, and sexual assault work, because you don't want to be heard to suggest that alcohol is the perpetrator. In fact, sexual violence is caused by evil people doing bad things. But I do presentations on this, others do as well. Alcohol and drugs can be weaponized against victims, and the correlation there is quite clear. We've been lately, and I've been working a lot with Vector and its predecessor, one of his predecessors, Everfi, on recent scientific information that's now demonstrating that small amounts of alcohol and drug prevention efforts have significant benefits to core mission delivery. Translated, better student retention and attainment rates are visible when doing this work. And of course, part of it too is liability prevention, because a great deal of the lawsuit activity out there does arise out of alcohol-related injuries. FERPA, this was the act I mentioned earlier. Sometimes I call FERPA the Registrar's Relief Act, because it does create the need for professionalized education record management. In recent times, we've seen issues with silos, particularly in people not sharing information across campus when they could do it. But we did see this August 2016 issue that came up when an institution did access and use medical records against a student, and the department responded by clarifying institutional responsibility for how and when uses protected medical records. FERPA sort of is on the connective line with sunshine laws, which require a lot of operation of institutions to be visible to the public. Takes a trained lawyer's eye, particularly a public institution, to how to walk the line between privacy and sunshine. But one thing to remember with FERPA is that you are allowed to share information in safety situations on a need-to-know basis. There's certainly more to the legal rules that follow that, but this is a truism that I think sometimes does get overlooked. Sovereign immunity. It's good to be the sovereign. And typically in lawsuits against a sovereign, there are specific procedural requirements and timeframes for lawsuits, caps on damages, often limits the type of damages. And then depending on which state you're in, you may be looking at official or institutional responsibility or one or the other. I know, for example, following Virginia Tech, the families were limited to a certain amount of damages per injured person, not a terribly large number, given that you were looking at 32 claims involving death. Aggregate number reasonably large, but each individual fairly low. Legislature can tack on more if they want to, but they do not have to. Hazing. I've done a lot of work in hazing in my career. And I'm sad to say that I don't know how much progress we really made. It's not just a fraternity issue. Hazing laws have developed at a state level to be much more specific. Florida and Pennsylvania particularly have avant-garde, cutting-edge anti-hazing laws that spend a lot of discussion about consent and assumption of risk and make that not something that someone can raise as a defense. I show you the Massachusetts law, reference Florida. But what we're finding is that this is a problem that seems very hard to stop simply by increasing punishment. I have noticed that hazing tends to correlate with people who are in their early teens and preteen period up till mid to late 20s and then dies off. Fascinatingly, that does correlate strongly in time with prefrontal cortex evolution in a human. I am not a scientist. I'm not sure what that might mean, but I'm beginning to think that the great hope and breakthroughs for hazing may actually come by learning more about how the human brain develops, and particularly how decision-making and risk-taking evolved during that time. This is one place where the law is needed, but it may not be enough. Who's responsible is always an issue. And then are we looking at civil, criminal, and regulatory responsibility? Often you get all three. From a campus point of view, you're going to find that these four things just naturally trail together, and making a decision on one implies others. Hazing, what's the difference with hazing from bullying? How is a hostile environment different from hazing or bullying? And what about hate speech? There is some Venn diagrammatic overlap with all of this, but I would say if you are discussing these issues with a campus legally, you kind of have to attend to all four of these if you're going to do any one of them. Today, it's more common, not ubiquitous, for institutions to enter into relationship agreements, and also to find some challenging dialogue around associational expressive right dialogue between an institution and a host group that may have had a hazing issue. This goes back to Healy and James creating these kinds of rights, where Healy both not only identifies the right to associate, but then also articulates that an institution does have the right to ask any association to swear allegiance to reasonable rules and regulations. Complex. Eric Hoover wrote a piece a way back that I still go back to, asking whether students are hardwired for hazing. Do we have effective techniques? Somewhat. I don't feel personally that we've gotten as far as we potentially will in this area. Mental health. This is now ranking as one of the top issues that keeps presidents and leaders up at night. And we have seen generational issues with millennials, Gen Z, and alphas coming, veterans, older learners, any student with differences of any kind, whether they're disabilities or not. For example, first generation college students, international students have been certainly on our radar screen, and sort of why are we seeing an uptick in many more higher ed students and graduate students with mental health issues? And some of the answer lies in the fact that disability law has actually been quite successful. Early generation disability law focused a lot on physical disabilities. But in more recent times, disability law has been much more focused, still, of course, on physical disability, but on emotional, mental, and experiential learning disabilities. And so you're seeing a great success in K to 12, translating into more people making it to our education level and bringing issues with them. Associated are so-called care and threat assessment teams. I'm privileged, I suppose, to have been at ground zero at the development of a lot of this work on many campuses. I noticed, particularly after the incident at Virginia Tech, that schools that had not emphasized care and threat assessment teams began to see an uptick. My own campus created one of these when I had a personal challenge with a student who came in and ideated self-harming, and we had no system in place at that time. We rapidly developed one. Again, this may go in a little more detail than is necessary, but just something that might help when you are building out a care team or a threat assessment team. You do want to think about the name, because you can't ride through the desert on a horse with no name. And whatever name you pick, people are going to come at you and say, that's what you should be doing. So if you're the concern team, people will expect you to be concerned. If you're a BIT team, behavioral intervention, people will say someone's acting badly, intervene. So be prepared to identify and articulate your scope and your mission, whether you're just working on students or students and faculty staff. Do you need a separate team for emergency response or risk management discussion, so-called ERM? I will tell you that if you're not clear about what you're doing and what you're not doing, people will just tell you that this is who they think you should be and get very mad that you're not doing that. Probably still do it to some extent, but it gets worse if you haven't really articulated. Making your team well-known on campus is almost a priority now, because we know that these are protective factors, particularly at students at risk. I mean, that's pretty well established at this point. So if people don't know how to access the team, where they are, phone numbers, et cetera, they are not going to be able to take advantage of that protective factor. Who do you put on the team? I just say this: if you have police officers, badged officers on a team, the badge always comes first. Counselors can listen, but they may not be able to share. And medical staff may have private medical information, and the teams need to respect the boundaries of professional activity around information about patients. So I've watched that dynamic sometimes get a little sketchy for people in these categories. Who will lead? I don't usually favor that the highest ranking person lead, because there'll be a tendency to toady to the leader. And then it doesn't always turn out that the top person in an area has the best skills for this kind of work. So when I've been consulting on this stuff with folks, I watch team dynamics very closely. And sometimes the best leader is somebody who's relatively new and not high up the chain. One of the things you'll find, and this is true in all of higher ed law and policy, it shows up a lot in care teams, is you have to make decisions about where the sorting hat, Harry Potter, best puts your problem for practical solution. I mean, do you have a legal problem just because it presents as one? Is this a mental health issue or safety or management? Is it a community-wide issue and not just a personal issue? And is it academic or a personnel issue? I can't tell you how many times people have come to me and they're like, I have a problem with the student in the class, their behavior is bad. And then when you look at it, you realize it's really not the student. The teacher is having challenging situation trying to run their classroom. And so the real conversation goes to an academic dialogue, not, shall we say, legal or behavioral. Lawyers get called in all the time to do policy review, but it isn't that unusual that when you get involved in policy review, you realize the policies aren't so bad. You have a personnel issue, or vice versa. You may think you've got a personnel issue when in fact there are policy problems. This has become a huge topic of discussion. Many states now are moving to ban DEI conversations in their public systems. And in fact, the Manhattan Institute's put blueprint legislation out to send to states that want to do that kind of work, and they're more getting in line to do it. And even bias response units have come under legal attack. These are two very famous cases, Cartwright and Fenves, that basically hold that bias response units run the risk, if not overtly cross the line, in chilling speech because they are sort of a pre-disciplinary system in the eyes of some people on campus. A really interesting development, because as schools want to move towards bias incidents or talk more about DEI, they may start butting up against some courts and some legislatures' idea of the freedom of speech or freedom of association that might be involved. Take you to a minute here. This is something I developed for another work, was just try to play out campus safety and the missions that have existed. And I think for people who are new to the business, this might be a little eye-opening. The 60s and 70s, campus police protected physical property. They weren't really there for students. And they often reported to business officers, not anyone else. It starts in the mid 80s, but really the 90s, where you start to see campus security now focusing more on foreseeable risk to students, particularly violent crime. Even in the early 90s, people were arguing that students had no rights to basic safety, be protected from foreseeable criminal assault in their residence halls. That starts to change in the 1990s. So does the Clery Act. The mid-90s through the early aughts saw a clearer connection with campus security and police and student life. And more the campus police, et cetera, were being asked to get involved in alcohol and drug intervention, peer violence, residential life behaviors, et cetera. And really more collaboration with student affairs than previously. I'll give you a couple examples here, both with going back to Mission 2 and Mission 3. The Mullins case versus Pine Manor came out of Massachusetts, early 90s. And the institution argued that students in residence life are owed less care than individuals in low-income housing. The Supreme Court of Massachusetts disagreed. One of the very first cases of its type. So it kind of gives you a timeline here. The Knoll case is in this Mission 3 period, and a student was involved in a hazing incident and was taken to an off-campus location. I recall he was handcuffed to a drain pipe at one point and tried to escape from an upper floor window, fell, was very injured. And when the court in that case reached decision, they made it fairly clear that campus security and the campus itself had a role to play in preventing an incident of that type. Mission 4 starts to move towards wellness and active shooter prevention. This is the Gross case, the tech report, I call it, particularly the state and federal reports on Virginia Tech. And now the Clery Act starts to shift towards having more than just campus crime reporting, but standards that actually require things such as timely and emergency warnings. Adding the next two missions, from April 11th forward, you see campus security much more involved with Title IX. And I've added Mission 6, and I think we're in the post-COVID world. And I think this one is really interesting because more than ever, I think campus security and police are being drawn into a wellness and belonging universe as people dust off from this protracted and really pretty terrifying and problematic post-COVID period. Clery Act requires an annual security report, so-called ASR. There was a handbook on how to put it together. It was rescinded. And we believe that a new Clery handbook is imminent, that we're getting word that one is coming from the department. We shall see. There is no private cause of action under Clery. Even the so-called VAWA-SAVE amendments, which were attached to Clery that deal with sexual violence. The new definition of sexual harassment in the Title IX regulations, that's 34 CFR 10630. Some of us call it 106.3, include Clery Act definitions in part, the so-called VAWA-SAVE ones. So there's overlap here. One of the lessons here is that the Clery Act had started out as a campus crime reporting bill, but is increasingly becoming sort of an omnibus safety bill for higher ed, but it is not comprehensive. It does not set reasonable care standards nationally. We have yet to have a clear, singular national standard for campus safety, and we may still be some time away from that. So I do quite a bit of work in the field that relates to litigation, and I thought it was only fair and I think appropriate to point out what is driving a lot of this litigation uptick. And I'm going to step back here for just a second, and here are some things, some themes that are pretty common in my work. Number one, I call it ambush. Sometimes students, faculty, or staff feel like they've walked into an experience, but they're not prepared for it, or they didn't know what the experience was going to be. And they feel ambushed by their institution. This often triggers resentment, as it would in any consumer relationship or commercial relationship. And a lot of the root issues in cases I've worked on go back to poor touch at first point of contact. The new Title IX regulations are sort of obsessive about not ambushing people with Title IX, and in part because the Department of Ed heard in listening sessions a great deal of complaints about that sort of behavior. I'm not saying it actually occurred, but if the customers think it happened, it did in a certain sense, and it may well have. Inconsistent internal results will drive litigation. So, I often beg my clients to not generate de novo review of prior investigations, because if you end up with inconsistent results, all you're going to hear from litigants is, well, even internally, you're not sure what the answer is. And if you process the same matter twice or three times to the same conclusion, people will just accuse you of having a process sort of Soviet justice style, where we keep trying people until we get the right result. Can't really win with that. Bias and fairness issues are dominating, and this is showing up a lot in Title IX these days. Maybe the biggest one of all, having policies and following the policies. So often what people complain about is deviation from stated policy, and getting that habit, that basic compliance habit of ticking the box on your policies and making sure that you're following them, it helps. Having overly legalistic policies and procedures. I think you might have heard me say this earlier, but if all we do is approach our student, staff, and faculty with legalistic procedures, they're likely to respond legalistically. And then the other thing that comes up quite a bit is what we do in the context when there's ongoing criminal justice activity. And this sometimes misstepping here can lead to some judicial intervention. Title IX, the ever expanding world. Gosh, it wasn't that long ago when I thought of Title IX, and most of us did, we thought of athletic equity. Occasionally a person still asks me, isn't Title IX a women's sporting goods clothing line? And I'm like, well, it is, but there's all this other stuff too. In recent times, litigation over everything that's on this slide has increased. And we really don't have time to go over all of this in any particular detail, but I want you to notice something, that you're starting to see Title IX mutate into a safety law as people talk about preventable sexual assault, which is very similar to a state negligence claim. We see Title IX intersecting with hazing and student suicide. And then many of the standards, particularly the ones that are more recent, seem to want to test the idea that you can have compliance error in the process of providing compliance. Now, I have to chuckle because if you go back to 2010, before that famous Dear Colleague letter about Title IX, a lot of people weren't in a position to have that kind of compliance error because they didn't really have the fully functioning grievance processes in the first place. But now that we're delivering court, we're told we have to have court and you have to deliver court in a court-like and correct way, multiplies the dimensions of litigation. I have now reached the final slide with just a few minutes remaining. And this was my great hope that I would leave at least a couple minutes for audience interaction. So I can kick it back to our hosts to see how they would like to manage our interaction, and see if there's any questions or any comments that are out there. And they can go in the chat too, if you'd like them to.
Thank you. I think usually what's been the easiest is if anyone has any questions, if they can pop them into the chat. And I know it sometimes takes a couple minutes for people to type them out, so we can give a few.
My beverage of choice today, of course, is grape soda. Very legalistic beverage. So I hope
Well,
that's
while we wait to see if any questions come in, thank you very much for all this information presentation. I certainly learned a lot, and I'm sure many others did as well.
I hope so. This is quite a plow. I feel like a snow plow on a deep snow day, and I really came at everybody pretty fast. I hope it was intelligible and helpful. Probably organizes your thinking around categories, each of which could expand. In my class, I teach, days on almost every one of these slides.
Yeah.
Oh, I see something in the chat. Maybe make the bad man go away. Oh, thanks. That's from Freight, everyone. I appreciate that feedback. At least one person is still alive out there, which is great.
Well, we'll give it another minute. Maybe you answered all the questions.
Well, sometimes I go right to the hour and then I feel bad that I haven't given enough time for interaction. I suppose if you have a minute and you're just chewing on some piece of legislation that you would like to raise or a case you might have heard about, there's a pretty good chance I can echolocate it from memory. But so far we're just getting praise, which is fine with me. Oh, here's one. Do you think the Title IX regs will require? Yeah, Jonathan asked everybody, do you think Title IX regs will require due process for employee matters that's the same? And I think the answer is going to be some level of yes. And I say that because of the way you phrase the question, the same due process. I think that they will almost certainly organize around what they believe to be the core requirements of due process, but then play it out maybe slightly differently for a Title IX or Title VII matter. I think Title IX itself will probably have to have similar standards, but perhaps they'll tune that a little bit. But I think that's been a big discussion point, is that usually the Title VII process looks a lot different from Title IX. And people have been struggling with that. I will say, Jonathan, that the trend in the field, whether it's good or bad, and I know some of the lawyers will just scratch fingernails on a chalkboard, is to start moving towards normalizing process around Title IX requirements. It seems easier. And people ask that question like, well, how come I'm not getting that? The one place I notice some deviation is when you have collective bargaining rights that are on top of Title IX, and that's where you may get some differential and permanent differential treatment. But yeah, I do think they're headed in that direction. Cool. Go Hatters. There you go, Jody. I love it.
Okay, last call for any other questions?
That's the last person through the gate. Stump the professor. Yeah, it's really been an honor to give some time to you all. I appreciate the invitation, and I know our center at Stetson is often putting on webinars and such that will fulfill CLE requirements in some jurisdictions. So please do keep an eye on my higher ed center down at Stetson for what we're going to do. I think we probably will be doing a Title IX update when the new regulations come out. So that could be May or June of this year.
Well, thank you again, and thanks for everyone for attending. If you are here not as a member of a nonprofit, we hope you will consider joining the section. If you are a member of a nonprofit, I did want to mention that we had sent out an update on our annual meeting last week, which includes some opportunities to get involved with the section going forward, including some pro bono opportunities. There in that email is some more information, and if you are interested, please respond to me. But other than that, this is going to conclude our March CLE series. So thank you, everyone, and have a great rest of your afternoon.